Welcome back to Protecting the Legal Rights of Artists and Designers. We're talking about contract law, and in this video, we're going to pick up with excuses, defenses, and remedies. All the things that you think about after you have a contract. Let me take you back to the contract process whiteboard. Once you have the basics of a contract in place, offer, acceptance, and consideration, is everyone going to be happy with the contract? Good if they are, but what happens if they aren't? Remember, in the process at that point, look at the defenses and excuses. Is there an excuse or a defense that would apply to the situation? If the contract's enforceable, did someone not do what they were supposed to do? You take them to court. Are there remedies that apply? Damages, specific performance, reformation and rescission. We're going to take a look at this part of the process. Excuses and defenses to performing a contract. Can I get out of it? Here are some potential options. Lack of consideration, where it may seem that there was an exchange of something of value, but in reality there wasn't. Nothing of value was exchanged. Lack of intent. One of the parties really didn't intend to enter into a contractual relationship. They didn't actually commit to the agreement. The offer wasn't genuine, or there wasn't acceptance. Maybe it was a joke, maybe a gift. Lack of capacity. The party is a minor, too young to understand, actually, or as a matter of public policy, or there's a mental infirmity like dementia that inhibits the person from understanding the consequences. Mistake. When the parties are mistaken on an important or material term to the contract. Fraud. One of the parties intentionally misleads the other party about important details. It could be a lie, or it could be a lie of omission. Non-disclosure. Duress. One of the parties is manipulated, coerced, or forced to enter into the contract. Unconscionability. One party takes advantage of the other party so grossly unfair that it shocks the conscience of reasonable people. Sometimes called a contract of adhesion. Take it or leave it. And there aren't any other viable options or alternatives. The other side holds all the cards. And undue influence. Someone in a position of trust takes advantage of the relationship for personal benefit. They whisper in the ear of that person and get them to do their bidding. Maybe it was void in the first place. You couldn't enter into the contract in the first place or affirm it even if you wanted to. Like a violation of the law, a criminal act, or maybe a violation of public policy or licensing. You've heard of stupid criminals who enter into a contract to kill someone, put a contract out on them, or to sell drugs. Someone calls 911 to get the police to come and make somebody pay for the drugs that they took. A contract to kill someone is not an enforceable contract, nor is trying to force someone to pay, and calling the police is not a smart move. Maybe it's a violation of a licensing law. That's going to depend on the type of license or regulation. So depending on if the purpose was to prevent somebody from being harmed, the contract could be void. Look at the purpose of the licensing. If it's for safety or competence, then a contract that violates the law is not enforceable. A license for an electrician or a plumber or a lawyer or a doctor, that contract can't be used to make that person perform because they aren't qualified to do the work. That's set to protect somebody. If it's a license for raising revenue, then you can still enforce that type of a contract. Like a vendor's license. That law wouldn't prevent someone from following the contract if they don't have the license, but they will be responsible for paying the fee, plus fines and penalties. An example I often use is for construction work, where you have a contractor like an electrician or a plumber, and they're supposed to be licensed to do work within that jurisdiction. If they don't have the license, then that contract can't be enforced. The plumber or the electrician or whoever the contractor is can't enforce that contract and force somebody to pay if they are not licensed. Public policy. Public policy can be another general defense or excuse for performing a contract. This is when there isn't a specific law that would prevent or bar the contract, but the results would be so unfair in the eyes of society that the parties won't be compelled to follow through, like unconscionability. Now, if there is a valid contract, no excuses or defenses apply. Then the parties could be in breach of the contract. Violating the terms of the agreement because one of the parties failed to perform. Someone didn't fulfill their obligations. They didn't do what they were supposed to do. So, we look at remedies to try and fix the deal. What can you get for your trouble? Remedies are the consequences that the parties try to enforce when they go to court. I'm taking you back a little bit with the Schutz and lawyers explanation that we had in class. What remedies can apply? We look at damages, including compensatory damages, trying to compensate for the loss or putting the parties back in the position either prior to the contract or if the contract had been performed and they received the benefit of what they were supposed to get. It's using money to try and substitute for this. You also have expectation damages, incidental damages, and consequential damages for any sort of incidentals or consequences that would accompany these losses. You've got nominal damages. This is where there isn't an actual loss, and so a small amount would be given as an award for someone who would win a case in court. Liquidated damages. This is where you would set amount ahead of time in the contract, normally in a situation where it would be hard to figure out what damages would be. So the parties would agree. Something like what you would see with a limited warranty, where it would limit the amount to a set dollar figure or to certain actions. And punitive damages. These are intended to punish someone who would breach a contract where their actions have been intentional or reckless, and it's to deter them and other people from doing that sort of thing. These are money damages or remedies at law, trying to make people whole by using money. Then there are equitable remedies, using the power of the court to create a certain type of outcome. Specific performance. That requires the parties to perform and complete the terms of the contract. This is usually reserved for circumstances where the services or the items are unique and it can't be substituted or replaced. The person has unique skills, such as an artist or a musician, that has special value. Rescission is another equitable power. Canceling the contract as if it never happened and restoring the parties back to where they were before entering into the contract. Return everything back to the original owners, no harm, no foul. And reformation, remaking the contract to match the original intentions of the parties. They wanted to enter into an agreement, but wound up with a misunderstanding instead. The court then remakes the contract. All right, that's a quick run through of excuses, defenses, and remedies. We will continue with contract law in the next video and finish with negotiations.